Hey guys, it's George again. I'm here to talk about negligence today. It is a tort that you can sue for in civil court to recover damages for an injury. Um, so and it's a really large part of tort. So we're just going to be going into the basics today of the elements of negligence. Just kind of what it is and what is required to meet that tort. So the first thing is that the defendant owes the plaintiff a duty of care. For instance, a doctor owes a patient or a hospital owes a patient a duty of care. Second, there is a breach of that duty. The doctor owed you a duty of care, and he, through no real intentional act, an unintentional act, he breached that duty of care. He didn't give you what you were owed. He didn't live up to the standard of the doctor, or the hospital didn't live up to their standard. The third element is there must be an actual injury or there must be damages. If you weren't injured, then it's no harm, no foul. However, if you do sustain injuries, then you're looking at a tort for negligence. And the fourth is the defendant must actually be the cause, either in fact or the proximate cause of those injuries. So, for instance, proximate might mean that the defendant hit a car or was driving a car, hit a tree, and the tree fell and hit you and you were across the road. That is proximate. He didn't hit you, but he caused your injuries. So the plaintiff must establish the defendant had some type of duty. So the duty of care, that's you owed me this standard of care. And then the defendant must actually be the cause of your injury. We use the standard of a reasonably prudent person. You'll hear this a lot, and it's kind of an underlying theme throughout law school is this reasonably prudent person right here. And we evaluate not on a case-by-case basis what that person was thinking or what was going through their head, because we don't want to allow people who are ignorant. We don't want ignorance to be a defense for negligence. People were injured, and while you might not have understood the danger of what you're doing, a reasonably prudent person would, and thus you're going to be held to this standard. That's the only way. Otherwise, people would it would be a lot more difficult. So that's the standard we use, and it's their assessment of the risk of harm. There's an expectation of society to evaluate the risk of harm in everyday life, to have foreseeable or recognizable danger. So people recognize the risk of harm and that is foreseeable or recognizable danger. So they use a higher level of care when they're involved with dangerous materials or something that could injure someone, heavy equipment, anything like that. You see there's a risk of harm. You see that it's recognizable danger, so you're going to be more cautious. Negligence is a tort of conduct, not of state of mind. So in criminal law, you have mens rea, which is the guilty mind. And in torts, you'll have intentional torts like assault and battery, trespass to chattels, things like that. Those are intentional torts. Negligence is generally considered an unintentional tort. You didn't intend to harm anyone. It was an action. You, through your own spaciness, accidentally did something and it injured someone else. You didn't intend to injure them. You feel really bad about it. It doesn't mean you're a bad person. It just means that you were reckless. Here's a little definition that was from a judge. Negligence is conduct caused by heedlessness or recklessness. The absence of due care has nothing to do with the person being a caring person. Just thought I'd throw that in there. And conduct exhibits lack of due care. Due care, the lack of care of a reasonably prudent person. Is not a state of mind. They may be a good person, but negligent conduct, then as my torts professor says, too bad, so sad, you're screwed. The care by a reasonably prudent person must be proportionate to the level of the danger of the activity. If it's really dangerous, then their level of care must be appropriate. So we have what's called a standard of care, and that's the reasonably prudent person. That's our standard of care, and it is invariable. That is the thing we go off of, is this one reasonably prudent person. I've yet to meet them, but they're there, and we judge people based on that standard. The degree of care is different. That is a matter of circumstance and is variable. It can change depending on your circumstances. Are you messing around with gasoline? Well, then you should have a higher degree of care. If you're, waving a pistol around, you should understand that it could kill someone. You should have a higher level of care with that, higher degree of care. So in the appellate court, they'll decide if there was an error made, if the error is reversible, or if it's harmless. Do they need to reverse and remand for a new trial, or is it so inconsequential and negligible that it wouldn't have any real effect on the outcome of the case, in which case they'll affirm. The standard of care, in more of a broad concept, is to create uniformity and subjectivity. We want to hold everyone to the reasonable prudent person standard so that it's fair, but we also understand that the facts of the case vary, circumstances vary, and we don't want to have something that's so rigid that people are we put an undue burden on people for accountability. So we understand it's a case by case basis, but we also understand that ignorance and heedlessness are not an excuse for hurting someone else. So the standard of care is an issue of law for the judge. What constitutes a reasonable person is a question for the jury. Law goes to the judge, fact goes to the jury. If it's a question of fact, the jury has to answer it. If it's a question of law, the judge has to answer it. And sometimes judges will step in and maybe possibly overstep their bounds, and things that should have gone to the jury for decision didn't, but that's grounds for an appeal, so you're cool. The community standard for what is reasonable, that's why the question of a reasonable person goes up to the jury. They're your peers. They're going to decide what is reasonable. And then we have this emergency. It's kind of side note. Just put like an asterisk next to it. But emergency in itself is a circumstance. And so, for instance, let me put it to you this way. If the danger of the circumstance, if it's a dangerous circumstance, you're playing with a pistol, the level of care you need to have goes up. If there's an emergency, the level of care you need to have goes down. So if, for instance, you swallowed a bunch of poison and you're going to die and you're not near a phone or anything, and you start speeding on the way to the hospital, and you're just booking through red lights, and you're trying to get to the hospital before you die. You hit a car and you seriously hurt the person in it. The emergency, your level of care that you owe other people is decreased because you have an emergency going on. It's kind of it's a defense to a negligence tort. So the emergency doctrine, you have no liability if you qualify for it. Yeah, so that's